on mute.
Check
Hello.
Yeah.
Check it. Okay, that's good. Well done. Okay, good. Thank Hi everybody, welcome back. Hope you can hear me okay. So today we shall be reviewing exemption clauses, and then we'll get on to misrepresentation, which we did start last time, but by way of revision with regard to exemption clauses. Just one moment while I try and organise my screen a little bit better. Okay. So where are my PowerPoints? Okay, I'm having trouble with my PowerPoints and getting the chat box lined up, everybody, so we'll just have a short break. We'll be resuming in about 5 minutes. Just a moment. if. And then bring it there. Alright, okay everybody, sorry about that. A bit of a technical problem there, but let me just check. I need to go back to exemption clauses, which is this one. Okay. Okay. Okay, I think we're all right now, everybody, so sorry about that. Thank you very much, Terry, for his assistance. So we're reviewing exemption clauses tonight, and remember what the exemption clause is, and I'll try and make my screen a little bit bigger. Okay, there you are. And I'm using just the one screen tonight rather than two because it's simple. All right. Yes. Okay, so I trust everybody. Can you see the PowerPoints and can you hear me clearly? If you just let me know, okay, and then I will carry on. Okay, so probably the best PowerPoint to summarise exemption clauses is on the screen. And remember what an exemption clause is. Make sure you know the definition. Remember your must-know definitions. Check your toolkit. Offer, acceptance, consideration, and exemption clause. Remember, it's a term in the contract which seeks to exclude or restrict liability or responsibility or risk for either misrepresentation, which we're going to get into again tonight, negligence or breach of contract. Okay? And remember, an exemption clause by definition then is raised as a defence to a claim of either misrepresentation, negligence, or breach of contract. So will it work as a defence? The answer is only if it satisfies the three tests of incorporation, construction, and the legislation. Okay? So let me let the people in who are here. So very quickly, with regard to incorporation by signature, remember the must-know case is Lestrange and Gorkop. Remember it says what? If you sign a contract, you are bound by all of its terms, even though you haven't read the contract, unless there's fraud or perhaps misrepresentation involved. Okay. So Lestrange and Gorkop, everybody, must-know case. That's from last time. Till don't forget about, till actually there was misrepresentation involved, so that's why it's a contrasting case. Incorporation by notice, the leading case, Parker and South East Railway, which gives us the test of the party relying on the exemption clause, take reasonable steps to bring it to the notice or attention of the other party. So that depends on the facts of each case. And all the cases are on the screen. Parker is your must-know case. All the other cases are just illustration of that. So Chaplin and Barry, the fact that the exemption clause was on a receipt, the court said the person relying on the exemption clause did not take reasonable steps to bring it to the attention of the other party, because you don't expect to find the exemption clause on a receipt. On the Marlborough Court, person hiring a hotel room, they signed the contract in the lobby, but the exemption clause was in the bedroom. So again, there was no incorporation by notice in Ollie. Okay? The other case don't worry about, and indeed all the other cases don't worry about, except perhaps Interphoto, Picture Library and Spurn and Benshaw, which say some exemption clauses so widely drawn, so consequentially, if you like, in the event that extra steps might have to be taken to bring it to the attention of the other party. Okay, and then interpretation and construction. Does the wording actually cover the breach? So it's a matter of the courts interpreting the wording of the exemption clause, but the courts used to be very strict on interpreting the wording, and okay. Okay, let me see. So I need to get the PowerPoint up again. Okay, sorry about that. We're just seeing the sound. I mean, if you have any hard to see and hard to listen. Oh, okay. I think the listening should be okay now. With regard to the PowerPoints, I'll make them as big as I can. Okay, good. And you've got hard copies of all the PowerPoints anyway, but well, of course, it's nice to see it on the screen as well. Okay, well, I hope we've got all our technical problems sorted out now. Can I speak a bit slower? Oh my goodness, yes, I can. This is always a tricky bit because if I speak too slowly, some of you will go to sleep. But what I'll do is that I will speak a little bit more slowly. Okay, let me just get this screen going a bit better there. All right, there you are. That makes the PowerPoints a bit bigger. And I can go up there a bit further too. All right, and then I can move you over a little bit as well. Oh my goodness, what happened there? Okay, so hopefully everything is sorting out. Okay. And then I'll try and get the chat box here. So please raise your virtual class window to virtual class window to. Okay, well, I'm using just the one screen tonight, so the PowerPoints take up about, 80% of the screen, so I hope you can see the PowerPoints all right. Thank you, Gwen, that the sound is much better. Okay, all right, well, I think we're sufficiently good with the sound, sufficiently good with the PowerPoints, so something about my voice. So before your voice, I cannot hear anything. Okay, now I hope the sound is all right. Well, Terry will come running back in if we have any problem. Okay, so with regard to interpretation, remember the only must-know case rule is Ailsa Craig. The court's now not going to strain the meaning of the language, and they will give the words their plain and natural meaning. The reason is because now we've got legislation, and the legislation, of course, is the Control of Exemption Clauses Ordinance. Okay. And the only must-know bit about the CECO, everybody, well, Section 2, the definitions, Sections 3 and 7, they're the really only must-know sections of the CECO. Section 3 deals with the reasonableness test together with Schedule 2. Section 7 deals with negligence. You cannot exclude liability for negligence causing death or personal injury. That's Section 7 sub 1. Section 7 sub 2 is you can exclude liability for other damage provided it is reasonable. Okay, so going back to the main PowerPoint. So when you're answering any question on exemption clauses,
you should have at least 3 subheadings. One would be incorporation, the other one would be construction, and the other one would be legislation. Okay, so make sure you know the definition of an exemption clause one more time. It's a term in a contract which seeks to exclude or restrict liability or responsibility or risk for either misrepresentation, negligence, or breach of contract. Okay, as far as I'm on my screen, the sound seems quite adequate. So those people who can't hear me, Mr. Chan, no sound. Anybody else having a problem with sounds, let me know. But I think we're okay generally because we've just fixed that up. All right, let's get on to misrepresentation. So remember, must know definition of misrepresentation. A false statement of fact, so it has to be, if it's true, then it's not a misrepresentation. So a false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor. So remember, when it comes to misrepresentation questions, 2 major areas. One is there a misrepresentation? And that's a question of applying the definition. Okay, Jan, sounds okay. I mean, I've just said that. Can hear you. Can hear you. Well, I still have sound. Okay, thank you very much. I'm sorry, everybody. I mean, Adobe Connect, isn't it marvelous? They change the system and then you have something for 1 screen and 2 screens. I'm using just 1 screen tonight because I think it's simpler. So if I had 2 screens, I could perhaps make the PowerPoints a bit bigger. But I think the PowerPoints are big enough, and also you've got hard copies of them anyway. All right. Would you mind enlarge your PowerPoint screen again? Oh, okay. Well, I'll make it as big as I can. There you are. And I can also do it this way. Yes. All right. Yeah. Okay. And I can make it this way. All right. Maybe I can make it down. All right. Okay. That's about as big as I can get with the screen. So I hope that's all right. All right, so everybody, with regard to misrepresentation, then make sure you know the definition, and you'll get, what, 50% of the marks in any question on misrep, if it's a full problem question, by analysing whether or not there is a misrepresentation. Well, obviously it's got to be false, not true. It must be a statement of fact. What do you mean by a statement of fact? Well, as opposed to a statement of opinion. Okay, I don't know. Only 1/4 of our screen. It means if it's on the screen, then what is it? Oh, all right, okay. I'll try and sort this out at the break, everybody. Maybe I can go to 2 screens later on. Okay. Oh dear. Zoom in screen. I don't know. Top right hand button. I don't know. Okay, so as long as you can see the PowerPoints, everybody, I know they might be a bit small, but you've got the hard copies anyway. So, Bissett and Wilkinson, a statement was made about the carrying capacity of a farm. Nobody knew because it hadn't been used for that purpose before. So a statement by one person was treated as a statement of opinion. So if the 2 parties have equal knowledge and experience, a statement by one will be treated as a statement of opinion. However, in the Smith and Landon House, we had the opposite, in which the one landlord was selling a property to another owner, and the existing landlord knew the existing tenant was not a very good tenant. He made a statement saying, oh, he's a very desirable tenant, and the court found that was a statement of fact because the new owner, the new landlord, did not know the existing tenant at all. Okay, so 2 good cases on the difference between statement of fact and statement of opinion. Not with regard to silence as misrep, then The only case to worry about, I think, would be with an O'Flanagan, because if somebody makes a statement which at the time they make it is true, but then circumstances change to make that statement false, and you keep quiet, well, that will be treated as a misrepresentation. Okay, and then with regard to the representee being induced, well, the court will have a look at the facts, and even if it's only one reason for entering into the contract, that will be good enough. So Edgington and Fitzmaurice must know case. The court said the statement made need only be one reason for entering into the contract. Okay, and then so Edgerton and Fitzmaurice, the must-know case. I would also suggest Redgrave and Hurd, even though it's a dubious decision in which a statement was made about the value of a solicitor's practice, and the selling solicitor said to the buyer, here are my books of account, you can check the figures for yourself. Well, they didn't check it and found out that the value of the practice was much lower than what was stated. And the court said that that was induced because the representee does not have to check the accuracy of the statement made. But you would think from a practical point of view, if you had a chance to check the accuracy of figures, you would do it. Okay, good. So it looks like our technical problems have been sorted out, I hope, for the time being. Oh my goodness. Okay. So moving on to the remedies for misrepresentation. Probably it's important to note that when you are making a misrepresentation, you are alleging misrepresentation. You've got to prove all the elements of misrepresentation, but also, everybody, you have to state what type of misrep that you are claiming. And there are three different types: fraudulent or dishonest, if you like, misrepresentation, which is difficult to prove. Also, there is negligent misrepresentation and innocent misrepresentation. So the first two types of misrepresentation, the representor is at fault. They're either dishonest or they're negligent. And at common law, I emphasize common law, not legislation. At common law, you could also get damages in the tort either of deceit for fraudulent misrep or the tort of negligence for negligence. Okay, so as I mentioned last time, misrepresentation is an area of law in which contract law and tort law do overlap. Okay, so when you are advising a client who wishes to make a claim for misrepresentation, number one, you advise them that they have the burden of proving misrepresentation. They have to prove all the elements of misrepresentation. A false statement of fact, not a statement of opinion, made by the party to a contract which induces the representee to enter into a contract with the representor. And the person claiming misrepresentation has to state what type of misrep they are claiming. And you can claim, you can state fraudulent, negligent, or innocent. Which one would you advise your client to claim? Well, the answer is on the screen, coming up. This is the key PowerPoint, this one. But before that, let's have a quick look at the three different types of misrepresentation. Let's say you want to claim fraudulent misrepresentation. Well, the problem with fraudulent misrepresentation is that it's very difficult to prove fraud. And the burden of proof would still be on the representee. Okay. And at common law, it's difficult to prove negligent misrep as well. And so if you're advising a person to claim, who's claiming misrep, what type they should claim, they should also always claim, negligent misrepresentation. Why? Because the answer is on the screen. So everybody, very important, and we are on page 106 on to page 107 of your course manual. Section 3, sub 1 of the Misrep Ordinance. Now, because it was very difficult to prove fraudulent misrep and indeed negligent misrep, legislation was enacted to assist the person claiming misrepresentation. Also, at common law, before the legislation, you couldn't get any remedy pretty well for innocent misrepresentation. So it was thought necessary to introduce legislation in the area of misrepresentation. And the legislation, of course, is the Misrepresentation Ordinance. And Section 3 sub 1 has changed the law quite a lot. Section 3 sub 1 says that if the representee is claiming negligent misrepresentation, then because of the wording of Section 3 sub 1, which is at the top of page 107, the burden of proof is reversed and put on the representor. Now, what does that mean? It means that the representor will have to prove he is not negligent. And this comes from the two words, he proves, which is the third line from the top of page 107. Okay? So that's a big step, because that makes it much easier to succeed in a claim for negligent misrepresentation, because the burden of proof is reversed and put on the representor. Also, the case of Howard, Marine and Ogden shows that it's a heavy burden of proof, because Howard, Marine and Ogden, which is not in your course manual in this area anyway, the representor made a statement about the carrying capacity of a ship. Turned out that that statement was wrong, but the person making the statement said, I'm not negligent because I relied on the Lloyd's Register of Shipping, which is regarded as the Bible in this area. But as it turned out, they should have made further inquiries. For some reason, their statement was indeed wrong. And so this case of Howard, Marine and Ogden illustrates that it's a heavy burden of proof. And thirdly, the level of damages for negligent misrepresentation is the same as fraudulent misrepresentation. Now, we haven't got on to remedies yet, but the level of damages you can claim for fraudulent misrepresentation is any damages that flow directly from the tort. Okay. However, with regard to negligent misrepresentation, you can only claim damages which are reasonably foreseeable. The wording is a bit vague, but what it means is that the level of damages for fraudulent misrep is much more generous than that for negligent misrep at common law. However, because of the wording of Section 3 sub 1, and in particular the two words so liable, which are the second line from the top of page 107, so circle those words, so liable, and also he proves. The court saying that the level of damages for negligent misrep is the same as for fraudulent misrep. And that's the case of Roy Scott and Rogerson in England and the Pepsi Cola case in Hong Kong. Now, for some reason, those two cases are not in your course manual. They should be. Okay. And so the big query here, of course, is, has the law become too generous to somebody claiming negligent misrep? And everybody thinks so, yes, because you're treating somebody who is merely negligent as if they are fraudulent. And I think you'll all agree with me, everybody, that's a bit unfair, because we are all negligent, we all make mistakes. I mean, look at me with my Adobe Connect tonight. Oh, am I negligent? I don't know. Well, I keep changing the systems anyway. We get there in the end. But if you were, so I'm negligent, I plead guilty, if you like, to being negligent with my Adobe Connect tonight. But if you accuse me of being dishonest, I say, hang on, you've gone too far. So this is what we call the fiction of fraud. The fiction of fraud. You're treating somebody who is merely negligent as if they are dishonest. And so everybody thinks this is wrong, and everybody thinks that the wording of Section 3 sub 1 should be changed. And indeed, in England, they are preparing to change the law, which is identical to Hong Kong. But Hong Kong, we haven't changed it yet. So at the moment, everybody, what's on the screen, everybody must know, because it's 40% of any marks on misrepresentation. Okay? the first 50% of the marks on misrep are, is there a misrepresentation? Apply your definition. Is it a false statement of fact or opinion? Has the representee been induced? Okay? And then, of course, the burden of proof is on the representee to prove that there is a misrepresentation. And remember also, the representee has to state what type of misrep they are claiming. And you always advise them to claim negligent misrep, because as the law currently stands, it's much easier for the misrepresentee, because the burden of proof is reversed and put on the representor. Because of that wording, he proves. So in the context of 3 sub 1, he is the representor. Okay. Also, Howard, Marine and Ogden indicates it's a very heavy burden of proof, and most startlingly of all, the level of damages is the same as for fraudulent misrepresentation. And that's because of the wording of section 3.1, so liable. So everybody get out your pens and circle so liable, and also circle he proves, because that wording has big consequences. He proves means the burden of proof is put on the representor. The representor then has to prove he's not negligent, and that could be difficult. And it's a heavy burden of proof, as shown by Howard, Marine and Ogden, and the words so liable mean that the level of damages is the same as for fraudulent misrep. So everybody thinks perhaps the law has gone too far the other way. Before the legislation, the law was a bit tough on anybody who was claiming misrepresentation. But now everybody thinks the law has gone too far, and isn't it too generous now towards a person claiming misrepresentation? Okay, good. So everybody, that's 40% of the marks on the screen. What are the other 10% of the marks? Well, you could, if the representor is somehow able to claim or prove, that he is not negligent, well, the misrepresentation will be an innocent misrepresentation. Before the legislation, the innocent misrepresentee pretty well got no remedies, and everybody thought that was wrong. And so section 3 sub 2 of the Misrep Ordinance does give a innocent misrepresentee a remedy, in the court can award damages, albeit on a lower scale, in place of rescission. Now, what is rescission, everybody? It's the remedy where the court can order that the parties be put back in the position they were before entering into the contract. The problem with rescission, though, everybody, is that there are bars to rescission. And what are the bars to rescission? Let me get my... Just a moment while I get my, it's PowerPoint number 8. So rescission and damages, they are the two remedies for misrepresentation. But rescission is very rare, really, because it's subject to bars, and even under the legislation, the court has a discretion to award damages rather than rescission of the contract. And rescission is subject to those bars on the screen, undue delay. So if you delay a number of years, then you're not going to get the remedy of rescission. Also, if the representee affirms the contract, in other words, he carries on as if the contract is viable, then that will be a bar to rescission. Also, it may well be impossible to put the parties back in the position they were before entering into the contract. And finally, it may well be that the subject matter of the contract has been passed on to a third party, and that cannot be undone. So rescission theoretically is available as a remedy for misrepresentation, but in practice, the courts almost all the time will grant damages. Okay, so you can get damages for negligent misrep. You can also get it for fraudulent misrep. But why on earth would you claim fraudulent misrep? Because it's difficult to prove fraud anyway. So you'll always go for negligent misrep. and the burden of proof is reversed and put on the representor. If the representor is able to prove he's not negligent, then he'll be innocent, and under section 3 sub 2, the court can award damages in place of, in lieu of. LIEU means in place of rescission. Okay, and there's one final technical point. If you get this right, you'll get 100% in any question on misrep. Because of the wording of section 3 sub 2, there is a debate about the situation where if rescission is barred, can the court still award damages? Well, Thomas Witter says yes, because the idea of the legislation is to give a remedy to an innocent misrepresentee. However, the other cases on the screen, Floods of Queensferry and British Aerospace, seem to say, and they are on page 108, because of the wording of section 3 sub 2, these two cases say that if rescission is barred, then damages cannot be awarded. Okay, so a bit of a technical point. All right, so let's quickly go through misrepresentation, everybody, and concentrate on the must-know bits. The first bit is make sure you know the definition of a misrepresentation. Must know, put a big circle around this PowerPoint, must know. A false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor. Important to note that the burden of proof is on the representee. So the representee has to prove all of the elements of misrepresentation. They've got to prove that the statement was false, they've got to prove it's a statement of fact rather than opinion, and they've got to prove that they were induced. Okay? And then the person who is making the misrepresentation has to also state what type of misrep they are claiming. And there are 3 different types, and you know which type you should claim. You should always claim negligent misrepresentation because of what's on the screen and what I've gone through again. Okay, so misrepresentee has to prove all the elements of misrepresentation, also has to state what type of misrep they are claiming, and you always advise your client to claim negligent misrep because of the legislation. Section 3 sub 1 has reversed the burden of proof and put it on the representor, so the representor has to prove he's not negligent. Howard, Marine and Ogden says it's a heavy burden of proof, and Roy Scott and Pepsi Cola have said because of the wording of section 3 sub 1, the level of damages is the same as for fraudulent misrepresentation. Okay, and that's because of those words, so liable. Okay, so what's on the screen, everybody? Must know, must know. What's on the screen is another 40% of all the marks on misrepresentation. So that gives you 90% of the marks of misrepresentation. 50% for proving misrepresentation and stating what type you're claiming, 40% for what's on the screen, and I would suggest the other 10% are raising the possibility that the representor may be able to prove he's not negligent. He still has made a misrepresentation, but he's an innocent misrepresentor. And so section 3 sub 2 does give scope for the court to award damages, albeit on a lower scale than under section 3 sub 1. But then this really technical argument, can the court award damages if rescission has been barred? Open question. Okay. Your course manual seems to say, it says, it is submitted that the reasoning of the later 2 cases, Floods of Queensferry and the British Aerospace case, it's submitted that the reasoning of those cases is more likely to be followed in Hong Kong courts in dealing with section 3 sub 2. No cases on that in Hong Kong yet. Okay, so everybody, misrepresentation, you get a question on that. You could get a question in either part A or part B of the exam. Remember part A, you've got 5 questions carrying 20 marks each. You've got a choice of 3 out of 5. Part B, there are 2 questions carrying 40 marks. You only do 1. Misrepresentation has been set as a question in both Part A and Part B. You could get, if you get in Part A, of course, it's a shorter one, and it'll be a sort of a bookwork type question, but it could come up in Part B with sort of full problem question. You may be given a situation and somebody has made a statement, and you're asked to advise the representee of a claim, possible claim for misrepresentation. Well, if you do, you know what to do. Number one, make sure you put down the definition of misrepresentation, and then you analyse whether there has indeed been a misrepresentation, and then tell the representee to state what type of misrep he's claiming. And of course you claim negligent misrepresentation, and you know why. And then finally, if the representative is able to prove he's not negligent, then he'll be innocent, and the representee can still get damages. Query whether or not if rescission is barred. Okay, good. So that's misrepresentation, everybody, and must know. Let's go back to all the vitiating elements. Oh, by the way, don't forget, everybody, if there is misrepresentation, what is the effect? Well, it renders the contract voidable at the option of the innocent party. If there's a misrepresentation and the representee doesn't do anything, okay, well, nothing's going to happen. The contract carries on, okay? So make sure you know the difference between making a contract void and making it voidable. If a contract is made void, it terminates automatically. The parties don't have to take any action. But if a contract is rendered voidable, that means the innocent party has the choice. They have the option. They can sit back and do nothing, in which case the contract carries on, or they can take action, and if they succeed, then the contract will be made void if they succeed in claiming misrepresentation. Also, don't forget the other vitiating elements also, such as duress and undue influence, render a contract voidable. So what's on the screen, everybody must know. Make sure you know what the effect is of misrepresentation, duress and undue influence. The effect is it renders the contract voidable at the option of the innocent party. So I've got that at the bottom of the screen, IP, innocent party. Okay, so we've covered misrepresentation. You'll notice the next item on the screen is mistake. Mistake, everybody, is should know, not must know. You're not... I don't think there's ever been a question in the exam on mistake. So we're going to go through mistake reasonably quickly because it's not must know, it's more should know. Okay, so, but there are some interesting cases in here. Okay, so let's, where are we? Oh, it's going up very slowly there. All right, so operative mistake. I've got operative mistake. Why operative? The answer is we all make mistakes, don't we? But when it comes to contract law, not all mistakes will render a contract void. Now, the interesting thing about mistake is that it does indeed render a contract void at the option of the innocent party. Watch out, that mistake renders a contract void automatically. So it's a very drastic result. Now, because it's such a drastic result, the courts are pretty reluctant to find that there is indeed an operative mistake. Okay, so bear that in mind, but we do need to work through the law on this because it's in part in the syllabus, but again, should know more than must know. So a mistake is operative if it is as to something which is fundamental to the contract, such as the existence of a subject matter of a contract. Remember, the three important terms in any contract: parties, property, price. Well, if you're making a contract for subject matter that does not exist, well, will be an operative mistake, okay? So it's something fundamental to the contract. What about if there's a mistake as to the quality of the subject matter? Well, usually that would not be sufficiently fundamental to render the contract void, okay? And as I say, not that many cases succeed in proving mistake. But if you do succeed, then the result is that the contract is made void ab initio. What do you mean by that? From the very beginning. Okay, the whole transaction's unscrambled, and none of the bars to rescission operate, and even third-party rights can be overridden. So the bottom line is the effect of an operative mistake is very, very drastic. The courts are very reluctant to find there is an operative mistake because the contract is ended. That's it, from the very beginning. With regard to mistake, there are three types of mistake. There's what we call a common mistake, a mutual mistake, and a unilateral mistake. Well, what's the difference? Well, a common mistake is where the parties are in agreement, but the agreement assumes some fact to be true, which is not. Okay. The leading case of this is Bell and Lever Brothers. Bell and Lever Brothers, everybody's a very complicated case. And they both parties were mistaken as to whether or not an employee was entitled to some payment when they were terminated. And Bell and Lever Brothers is a very complicated case because it's on the top of page 109, because the judgments in the case, the reasoning is very hard to follow. Okay. And so even though Bell and Lever Brothers is cited as an example of a common mistake, it wasn't sufficient to make the contract void. A good case in which a common mistake renders a contract void is Galloway and Galloway, which is on page 109. I have actually got that on my PowerPoint. No, but Galloway and Galloway is a good one. The defendant, believing his wife had died, married the plaintiff. Whoops. The two parties later entered into a deed of separation under which the defendant promised to pay the plaintiff a weekly allowance. The defendant then discovered his first wife was alive, that must have been a shock, and stopped paying the weekly allowance to the plaintiff, who then sued to recover the arrears of the weekly allowance, and the court held that the plaintiff's claim was bound to fail because the separation agreement was void on the grounds it was entered into under the common mistake that both parties were legally married. They thought they were legally married, but they were both wrong. Okay. So Galloway and Galloway is a good case. Strickland and Turner is very similar to Galloway and Galloway. Okay, you thought the person you were married, and you thought your husband or wife was dead, and you remarried. Well, that's a pretty big mistake. Mutual mistake. What do you mean by mutual mistakes? Where the parties are at cross purposes. That's the common. I've got Galloway in this one. Yeah, separation agreement. Second one was void for common mistake, as the wife was not dead. Great Peace Shipping, Solly and Butcher, very complicated cases. Solly and Butcher, there was a Lord Denning case. And in that particular case, Lord Denning said you can have a common mistake at law, which is not a common mistake in equity. And the law was very complicated in this area. Great Peace Shipping, which is a much later case in 2002, the court said if there's a common mistake at law, it has to be a common mistake in equity as well. Don't worry about that complicated law with regard to Great Peace Shipping, okay? But with regard to mutual mistake, it's where the parties are at cross purposes, and this is illustrated by the case of Raffles and Wicklehorse. And in this particular case, both parties made a contract to hire out a ship called the Peerless. Turned out there were two ships called the Peerless. And one party thought it was this Peerless, and the other party thought it was the other Peerless. So the parties were at cross purposes, but they didn't know this, and the court found that that this was a mutual mistake which rendered the contract void because there was obviously no meeting of the minds. Okay. there's absence of proper offer and acceptance. And the other type of mistake is probably the most interesting one, and that's unilateral mistake. And a unilateral mistake is where one party makes a mistake, the other party knows about it and then tries to take advantage of it. And a lot of these cases deal with so-called rogue cases. Ingram and Little, Lewis and Avery, they concerned persons who entered into a contract with somebody who was a fraudulent person, who was a rogue. And so they entered into a contract, and for example, Ingram and Little, the Ingrams sold a car to somebody who they thought was a famous actor. Turned out he wasn't. And so the actor, the rogue, paid by check which bounced, but in the meantime, the rogue had sold the car on to a third party. And so the question was this an operative mistake? And the courts in Ingram and Little, Lewis and Avery, and Cundy and Lindsay, boil down to this. The courts are saying if you're dealing with somebody face to face, it's assumed identity is not an issue. You are assumed to be dealing with the person who's sitting right or standing right in front of you. And so there will be no operative mistake as to identity if you're dealing with somebody face to face. You could have an operative mistake as to identity if you're dealing at arm's length. That's the Cundy and Lindsay case. Okay. Also, it's interesting, if you are saying you're somebody who you are not, that is also a misrepresentation, because you are making a false statement of fact. You're doing it not by words but by action, and that would induce the other party to enter into a contract with you. Okay? So unilateral mistake, is also a misrepresentation. What type would it be? Would it be fraudulent misrepresentation, because you're saying you're somebody who you are not? Okay. Okay, so that's a mistake, everybody. I've gone through it pretty quickly because it's probably more might like to know. It's not really, certainly not must know, perhaps should know, but that's it. The only sort of interesting case I think that's worthwhile spending a bit of time on here is the Tree and Digiland Mall case, which again is not in your course manual. I don't know why not, but this is an interesting one which I think we can all relate to. It's actually a Singaporean case where somebody was on their computer at night, just like we are, and they noticed that a laser printer had been sold, advertised for selling for just $66 US, which is very, very cheap. It's supposed to be $3,854 US. Okay, so this person realized that the person selling the printers had made a mistake. And so they called up all their friends, so they all placed these orders for these, what they thought were very cheap laser printers. Well, they were very cheap at that price, but the court said this was an operative unilateral mistake. There was a mistake by the seller, obviously. The other parties knew it, and they tried to take advantage of it. Okay, and so the Singapore case of Tree and Digiland Mall is an example where the court found that there was an operative unilateral mistake, which meant what? That all of those sales contracts were void from the very beginning. So nobody got their laser printer for $66 US. All those contracts were made void for unilateral mistake. Okay, don't worry about the Chinese University of Hong Kong and Blue Cross case. That's just another example. But Tree is the interesting one. Tree is the interesting one. Okay, so that's mistake, everybody. We've gone through it quickly, but that's it. Okay. One final point on mistake, I suppose. In this area, there are two very, very narrow areas of law. What is rectification? It's a remedy for where there's a document where there's an obvious mistake. So the court can give an order that a document be amended. Okay, this could be, when there's an obvious typo, whatever, where, you might have misspelt your name slightly. Okay, but an action for rectification rarely succeeds. Again, we don't need to worry about that in any great detail. There's also another one which is even more if even very narrow, is that there's a defensive known as factum. What on earth is this? It's a Latin word for saying this is not my deed. So it means that I've signed a contract, but I didn't know what I was doing. Is that a defense? Okay, and the court said no. And the reason why I'm going through this is simply to remind us, everybody, of the case of Lestrange and Grawcop. Remember, Lestrange and Grawcop says if you sign a contract, you are bound by all of its terms, even though you haven't read it. Okay, and so what's happened here is that somebody signed a contract and they say, whoops, I didn't know what I was doing. Okay, or I'm signing a document which I think is radically different from what I thought I was signing. Okay, and this is a defense which rarely succeeds, because if you sign something, then you're at least negligent, and that wouldn't be sufficient. Okay, very difficult to establish the defensive known as factum of this is not my deed, which again means that whenever you sign anything, make sure you know exactly what you're signing. Okay. So it reminds me of President Biden today signing all of those executive orders. Okay. All right. Again, should know, might like to know, none of this on mistake, everybody, is must know. That's why I've gone through it quickly. But you should be aware that there is this area of law called mistake, or to be more accurate, an operative mistake can render a contract void from the very beginning. It's a very drastic result. The courts are very reluctant to find it. There are very few cases on it. Okay, in fact, there has been a suggestion the whole area be abolished, but I don't think so. The doctrine of mistake can live on in a very narrow area. You should be aware of it. It's not examinable, but you should know what it is. But one reason for going through it, everybody, is to illustrate the distinction between when a contract is made void and when it is made voidable, okay? And make sure you know the difference. Now, with regard to misrepresentation, remember, misrepresentation, as we looked at earlier today, renders a contract voidable at the option of the innocent party. If the innocent party does nothing, the contract carries on. But if the innocent party takes action and successfully claims misrepresentation, then, well, they don't have to void the contract. They have the option. Okay. Whereas with regard to mistake, if mistake is established, the contract terminates automatically. It is void from the very beginning. Okay, so that's misrepresentation, that's mistake, and that brings us on to the next vitiating element, which is duress, in particular economic duress. So we'll cover duress tonight, probably also cover undue influence tonight, and we may or may not get onto unconscionability, but certainly we'll cover duress and probably undue influence tonight. Okay, but I think it's now a good time for our break. So where are you? So we'll have a 10-minute break now. welcome back, everybody. Hope you had a good drink. I had some hot chocolate. Yes, I got the message from Mr. Just a little note about the... Okay, yeah, I'm in a classroom. And so... Not sure we can do much about. I've actually got a microphone as well, which is hopefully makes the sound a bit better. And I will slow down a little bit, okay, because I can't really change the sound system. I mean, I've got I'm looking at my screen. I've got really healthy green bars, which says that the sound is good. Okay, so. I am in an empty space. I'm in an empty classroom, and it's quite a big classroom. So I shall speak a little bit more slowly. And anyway, if you've got any comments about the reception, let me know. All right, I mean, I hope we can get back to being face-to-face before too long. And of course, we're going to have 2 revision sessions a bit later on in the year. I'm not sure when they are, April. So hopefully we can all get back to face-to-face before long. Anyway, the advantage of these sessions, of course, is that they're being recorded. So you can play them back again. And then that's the advantage. All right, so before the break, we looked at misrepresentation. Misrepresentation must know the definition, must know the 3 different types of misrepresentation, and of course, make sure you know the remedies for misrepresentation and the fact that you always advise your client to claim negligent misrepresentation. You know why, don't you? You should be able to tell me without looking at your PowerPoints. Number 1, the burden of proof is reversed and put on the representor because of the 2 words he proves in section 3.1 of the Misrep Ordinance. Number 2, it's a heavy burden of proof as shown by the Court of Appeal decision in Howard Marine and Ogden, in which reliance on the Lloyd's Register of Shipping was insufficient for the representor to prove he was not negligent. And last but not least, the so-called fiction of fraud. That because of the 2 words so liable in section 3.1 of the Misrep Ordinance, the courts are saying that that wording means that the level of damages for negligent misrep is the same as for fraudulent misrep. Okay, it is a fiction of fraud. So everybody thinks it's wrong, but the courts, both in England and Hong Kong, say, well, look at the wording of section 3.1. That's what it says. And so the law it's controversial, and in England they are thinking of changing the law. Hong Kong hasn't quite got that far to considering changing the wording of section 3.1. But remember, you know what the word law means, that which is laid down. So the law is on remedies for misrepresentation has been laid down in the Misrep Ordinance, and that's what it is. Okay, now, if you have a look at your course manual on page 106, there's a heading at the bottom that says Statutory Misrepresentation. A rather strange heading in my view, because what do you mean by statutory misrep? Well, with regard to misrepresentation itself, the law is the common law. It's not statutory law, it's the common law. I think what they tried to say in the course manual when they said statutory misrepresentation, towards the bottom of page 106, is that the remedies for misrep are in legislation. Okay, and that's a good reminder, everybody, that when it comes to misrepresentation, 2 big areas. Number 1, is there a misrepresentation? So that's the definition of misrepresentation. And remember that the representee has to prove all of the elements of misrepresentation. Has to prove it's false, it's a statement of fact, and that he was induced. And then also has to state what type of misrep he is claiming. Once the representee does that, then the legislation kicks in with regard to the remedies. And Section 3 sub 1 says that if you are claiming negligent misrepresentation, the burden of proof is reversed, put on the representor, and it is a heavy burden of proof. Okay, and that the level of damages for negligent misrep is the same as fraudulent misrepresentation. Okay, so very important, misrepresentation, whether or not this misrepresentation, apply the definition, apply the common law, in other words, the case law. Okay, so what do you mean by the case law? Well, for example, Bissett and Wilkinson, Smith and Land and House, on whether or not it's a statement of fact or a statement of opinion. Also, those cases on whether the representee has been induced, such as Edgington and Fitzmaurice, and also Redgrave and Hurd. Okay, and once the representee has proven the elements of misrepresentation and stated what type of misrepresentation he's claiming, then, if you like, the ball is in the court of the representor. And in Section 3 sub 1, if you are claiming negligent misrep, as I say, the burden of proof is reversed and put on the representor, and the level of damages, should there be a negligent misrep, is the same as for fraudulent misrep. And we haven't got to remedies yet, that's Chapter 5, I think it's Chapter 5, but and with regard to remedies, the most common remedy for breach of contract, or indeed misrepresentation, is damages. Okay, and even though it's theoretically possible to get the remedy of rescission for misrepresentation, because the remedies now are in legislation, the court has a discretion. So even if rescission of the contract is possible, the court has the power to grant damages in place of rescission. So invariably, the remedy you get for misrepresentation will be damages. Okay, all right. So that's misrepresentation. Mistake, of course, we just covered, albeit fairly quickly, because mistakers might like to know, or maybe should know, but certainly not must know. The important thing to note about mistake is that if there is an operative mistake, what effect does it have on the contract? Well, unlike misrepresentation and duress and undue influence, mistake renders a contract automatically void from the very beginning. Okay? So it's a very drastic result if there is an operative mistake, and there aren't that many cases involving an operative mistake. Okay. All right, now we're getting on to duress. And duress, if it is proven, renders a contract voidable as well. Make sure you appreciate that. Okay, what is the effect of duress? It renders a contract voidable at the option of the innocent party. Okay, and duress starts on this PowerPoint. So we have already covered duress when we dealt with economic duress, when we dealt with, remember, the element of consideration in the case of Williams and Roffey. Remember, Williams and Roffey, the main issue in Williams and Roffey was, can performing your duty under an existing contract be consideration for the variation of the contract? Well, normally no, because remember, consideration means reciprocal benefit and detriment. So if you're performing your existing duty under a contract, you are suffering no extra detriment. However, Williams and Roffey says that if the elements that we discussed in Williams and Roffey exist, then that could be good consideration. Okay, but remember, one of the restrictions on Williams and Roffey saying that there can be valid consideration for performing your existing contractual duty is if there is economic duress exerted on the promisor. Okay. Now we have covered duress before, and in particular the type of duress called economic duress. But when we talk about duress here, we're talking about the broader meaning of duress, in which it's a common law doctrine, okay? It's a doctrine at law where unlawful threats to a party to a contract can render a contract voidable at the option of the innocent party. Obviously, if you threaten somebody with physical violence, and if they don't enter into a contract with you, well, I was going to say that's not right, but that will mean that you're not voluntarily entering into the contract, okay? And so the innocent party can take action and the contract is voidable at the option of the innocent party. And some other drastic cases here, sort of dramatic cases on duress. First of all, Barton and Armstrong. I'm just checking where it is. Yeah, Barton and Armstrong on page 119 of your course manual. And in Barton and Armstrong, there was a threat of physical force against the coerced party. Barton was the managing director of a company that agreed to pay 140,000 Australian dollars to Armstrong, the chairman, and to purchase Armstrong's share in the company. But before the agreement was made, Armstrong threatened to kill Barton. We can't threaten to kill somebody and then put pressure on them to enter into a contract. If he did not make the arrangements, Barton later sued to have the agreement set aside for duress, and it went all the way to the Privy Council, and the court said yes, albeit a split decision, a majority decision, that Barton was entitled to have the agreement set aside, despite the fact that it may have had business reasons for entering into the agreement. Okay, because you can't threaten somebody with physical violence to enter into a contract with you. So a threat of physical violence to one of the parties renders the contract voidable at the option of the innocent party. So that's fine, but we're really more interested in what economic duress is. I've also got on the screen, you can also have duress of goods. You threaten to, damage somebody's property. But that's really old law. The modern version is called economic duress. So what is economic duress? Well, we've already looked at that before. It's where one party places illegitimate pressure on the other party. How do you do that? By making a threat to do something illegal, such as be in breach of contract, plus the other party having no practical alternative but to agree, and there is protest by the victim. Okay, so we'll go through these cases on economic duress again. We did go through them before when we dealt with Williams and Roffey. Because remember, Williams and Roffey says there can be valid consideration for performing your existing duty, but remember the elements of Williams and Roffey. And in particular, if there is economic duress exerted on the promissor, then that will not be valid consideration. So let's have a look at economic duress, because that's what we're really talking about here. This is the modern form of duress, if you like, and it's the must-know. But you could get a question in Part A of the exam just on economic duress. Explain the elements of economic duress and indicate what is the effect of economic duress. Well, remember, the effect is to render the contract voidable at the option of the innocent party. Okay, so what are the elements for economic duress? This is sort of revision. You need a threat to do something unlawful, such as a threat to be in breach of contract because you're not accepting the original terms of the contract. Okay. Plus, no practical alternative for the other party, because, as in Williams and Roffey, you could, in other cases, it could be that the other party cannot get somebody else to do the job because of lack of time or lack of expertise. Okay. And there must be some protest by the innocent party. So this element of protest is quite important, because the courts will not find there's economic duress when it's simply somebody driving a hard bargain. So where do you draw the line between legitimate pressure, you like the rough and tumble of ordinary commercial dealings, which is perfectly legal, and illegitimate pressure, which is not acceptable? Well, the courts really look to the evidence. And of course, if you're alleging economic duress, you've got to prove it. So to look at the evidence of it, and in particular, has the innocent party protested? And you'd have to produce evidence of protest, such as something in writing. Say, for example, we had a meeting, and in the meeting they said that they were not going to stick to the original terms of the contract. We pointed out that we didn't have any practical alternative but to agree. We said we agree but under protest, and we reserve all our legal rights. And if you put all that in writing, that would be pretty good evidence of economic duress. Okay? Remember the general legal principle here, everybody. He who asserts must prove. So if you are alleging or asserting economic duress, you've got to prove all the elements of economic duress. You've got to do, and they would be a threat to do something illegal, the fact that you have no alternative but to agree, and you have protested. Okay? So the leading case on economic duress is the Privy Council case, Hong Kong case, Pow On and Lau Yu Long. Okay. Also, I've got a case there called Estinar. Yeah, let's just checking whether, Pow On, everybody, is on page 122 of your course manual. Pow On itself, don't worry about the facts of Pow On, a very complicated case involving several issues. The important thing about Pow On, it went all the way to the Privy Council, is that they confirmed the elements of economic duress, particularly this element of protest. Okay, and on page 123 that is, you notice about one quarter of the way down the page, you've got those 4 points basically giving us the elements of economic duress. So, I mean, the first one they've got there is, did the victim protest? Okay. Was there an alternative action open to the victim? Was the victim independently advised? That's it. Did the victim take steps to avoid the contract? Anyway, so what I've got on the screen, everybody, is the must-know bit. Threat to do something unlawful, plus no practical alternative for the other party, and protest by the innocent party. You can prove all of those, then you can prove economic duress, and therefore the contract is made voidable at the option of the innocent party. And usually you would want the contract to be voided, but of course you don't have to. You've got a choice. Okay, the contract doesn't automatically terminate. You've got to take action to terminate it, and you take action by informing the other party, hello, we've proved economic duress, so we are terminating the contract. But this element of protest is quite important, and there are other cases dealing with this element of protest, which we don't need to worry too much about. Atlantic Barron, everybody, on page 121, that's an interesting case. And Atlantic Barron, there was a contract and the pricing was in US dollars. Is that right? The plaintiff hired the defendant to build a ship for $300 million US dollars, payable in 5 installments. But after the first installment, US dollar was devalued, and so the defendant then asked for additional 10%. Was that economic duress? Okay. This was a threat to do something illegal. In other words, not stick to the original terms of the contract. The other party had no practical alternative to agree. Why not? Because they were contracted to another party and they would be in breach of contract if this contract had not been completed. So the court found that there was economic duress in the Atlantic Barron case, also known as North Ocean Shipping and Hyundai, on page 121 of your course manual. Okay. But again, you have to protest. There was protest at Atlantic Barron. The problem with Atlantic Barron, though, is that they did not act promptly. And if you don't act promptly, then you cannot claim economic duress. I think Atlantic Barron, they delayed, I think, 6 months, and the court found that there was the claim, if you like, of economic duress had lapsed. Okay, but what are the boundaries of economic duress? Good question. There is a case on the screen called CTN Cash and Carry, which is not in your course manual. I mean, can you have economic duress where the threat is not to do something illegal or unlawful, but a threat to do something lawful? For example, if somebody owes you money, then it's lawful for you to enforce the debt. But so normally that would not be economic duress, unless, of course, you overstep the mark. Okay. I've got a question there from 821. I'm not sure what that's all about. Okay. So that's economic duress, everybody. What's on the screen? Must know. Make sure you know the elements of economic duress. There are 3 of them. It's almost a definition, economic duress. Okay. What you must be a threat to do something illegal, such as not stick to the original terms of the contract, so you're in breach of contract, plus no practical alternative for the other party, probably because there's not enough time to get somebody else to do the job, okay? And there must be protest on behalf of the victim. And this protest point is very important. Powell, Lord Scarman emphasised this need for protest because this makes it clear that the pressure is illegitimate rather than legitimate pressure. Okay, so Power 1, must know case on economic duress. Atlantic Barron's a good example of economic duress, the elements, okay, a threat to be in breach of the contract because they wanted extra money because the US dollar had depreciated. The other party had no practical alternative but to agree because they needed this contract to be completed, so otherwise they would be in breach of contract because they wanted a ship to be built and they'd already entered into a contract to use the ship. Okay. And of course there was protest. The problem with Atlantic Barron is that they then delayed in taking action, and so the action lapsed. Okay. And what are the boundaries of economic duress? Well, can you establish economic duress if you make a threat to do something lawful? The courts have left the door open a little bit on that. I mean, it is lawful to enforce a debt that somebody owes you, but you know, some people might go to extremes, might hire, I don't know, some sort of agency which might be involved in criminal acts, etc. Then that could be economic duress. Okay, so the first 2 bullet points I'll suggest to everybody is must know. The 3rd bullet point on the screen, should know. Okay, just more an academic argument exploring the boundaries of economic duress. Excuse me, I'm having my hot chocolate. Lovely. Okay. And remember, if economic duress is established, it renders the contract voidable at the option of the innocent party. Watch out for that. That's very important. Okay. By the way, in Williams and Roffey, do you remember Williams and Roffey? In Williams and Roffey, economic duress was not pleaded. And some people say, well, perhaps it should have been pleaded because, well, there was no sort of direct threat. The court saying there was no sort of express economic duress, wasn't that sort of implied economic duress, because you could deliberately work slowly, be behind schedule, and that would force the other party to come to you and offer you extra money. And so there is a sort of a good argument for saying that in Williams and Roffey, the main contractor should have actually argued economic duress, but it wasn't pleaded, so the court didn't have to consider it. Okay, so watch out for economic duress. I mean, Williams and Roth, everybody, must know case on consideration, and make sure you know the facts of Williams and Roth, because they can come up in exam questions. Okay, so that's duress, everybody. And remember, duress is a doctrine at law. It's a common law doctrine. So go back here. Where is it? Here. And make sure you know the elements of economic duress. Economic duress could come up as a question in Part A of the exam. It could also come up in Part B of the exam as part of a Williams and Roth type scenario. In fact, you could have a question in Part B of the exam in which you have facts similar to Williams and Roth, but the facts have tweaked a little bit. So there is strong evidence that perhaps there was economic duress. Okay. All right. So what's on the screen, everybody? Must know, and also must know the first two bullet points on the screen at the moment. Okay. So that's duress. Now we get on to undue influence. What is undue influence? Well, first thing to note about undue influence, everybody, is that doctrine in equity. If you like, it's the equitable equivalent of duress, but it involves a much more subtle form of pressure. There is no definition of undue influence, but it does arise out of the relationship between parties to a contract. Now, you're all on Facebook or whatever, everybody. You're all on social media. You're all in relationships, okay? So I hope you find this sort of interesting. What about your relationships? Are your relationships equal, or are your relationships such that one party is a dominant party and the other party is the servient party, or if you like, the weaker party? Because this is the type of thing we're talking about here. We're talking about relationships where one party is dominating the other party to such an extent that they unduly influence the weaker party to enter into a contract with them. Okay, so we are focusing on relationships. It is a form of duress, but it's the equitable form of duress. It's a much more subtle form of duress or pressure. Okay, and so excuse me, that's the first thing to note. It arises out of relationships between the parties. It's much more subtle. Remember, with duress, which is the common law doctrine, threatening physical violence is not very subtle. Okay, whereas with undue influence, it's it's not so, not so subtle. It's much less, sorry. It's a much more nuanced type of pressure. And there are two different types of undue influence. The less important type is what we call actual undue influence. And the problem with actual undue influence is trying to prove it. You've got to prove that undue influence was exerted on you by the stronger party, okay? And that can be very difficult to prove in practice. We're going to look at a case called BCCI and Aboudi in a moment. And so that's possible, but the problem is being able to prove actual undue influence. And so the other type of undue influence, which is the more important one, is what we call presumed undue influence. Now, what is presumed undue influence? It's where the court will look at relationships, and in certain fixed relationships, such as parent-child, solicitor-client, doctor-patient, there will be a presumption that there is undue influence exerted by the stronger party on the weaker party, but it is a rebuttable presumption. Okay, so when we're talking about presumed undue influence, perhaps we should add in the word rebuttably presumed undue influence. Okay, and case law, which we're going to look at the moment, classifies these as there's a Class 2A and 2B. Class 2A we call is these fixed relationships, parent-child, doctor-patient, solicitor-client, okay? But there are other relationships which some of the cases called Class 2B relationships, which is sort of a useful classification. And in the Class 2B relationship, it's the other relationships apart from parent-child, doctor-patient, solicitor-client, in which if you are alleging undue influence, you've got to prove that there is a relationship of trust and confidence, and that you have reposed trust and confidence in the stronger party, and then you have entered into a contract with that stronger party, and a contract which calls for an explanation. In other words, why did you enter into that contract? There's nothing for you to gain and everything to lose. So that's what we mean by calls for an explanation, not explained by the ordinary motives of ordinary people. So in this Class 2B relationship, the person alleging undue influence has to prove, first of all, a relationship of trust and confidence. Okay, I relied on him because he was the expert type of thing. Okay, and then 2B is the other relationships in which the person alleging undue influence has to prove they've reposed trust and confidence in the other party, plus then entered into a transaction or a contract which calls for an explanation. Okay, we're getting we're getting on to the Class 2A and 2B shortly. I'm sort of summarising briefly what we're talking about here with regard to undue influence. No, not a duty of care. When we get on to negligence later, when we get on to the tort part of the course, the duty of care, we'll see, applies in a much, much greater range of circumstances than we're talking about here. Also, duty of care is related to negligence tort law and not really relevant to contract law. Okay, so I hope that answers that question. All right, so let's expand on what's on the screen at the moment. So what's on the screen at the moment is a bit of an overview of undue influence. But don't forget this point, everybody. If you can prove undue influence, it makes the contract voidable at the option of the innocent or weaker party. Okay? I want to say weaker, innocent. Okay, so don't forget that. And also, the third bullet point, everybody should know, not must know. The third bullet point is a situation which came to light really in the global financial crisis. There are a lot of cases in which one of the, I hope I don't sound too sexist here, let's say husband and wife, in which the wife enters into a contract with a bank. The bank will lend money to the wife, but the wife will put up the family house or an asset as security for the loan. And the issue might be, has there been any undue influence exerted by the husband or the stronger party on the weaker party, so that the weaker party enters into a contract with a third party, in other words, the bank. Okay, so there are a lot of situations there in which the wife or the weaker party was alleging that, you know, the stronger party exerted undue influence on them to enter into the contract with the bank, and then, of course, they were unable to repay the loan, so the bank then enforces this guarantee contract, and so the wife would plead, no, I entered into the contract with the bank because of undue influence exerted on me by a third party. Okay, and so lots of cases on that, and the leading case on it, on undue influence overall, is a case called the Royal Bank of Scotland, and Ettridge. Ettridge is a must-know case when we get to it. Okay. So, with regard to undue influence, make sure you know what it is. It's a doctrine in equity. It's the equitable equivalent of duress, but it involves much more subtle form of pressure. There is no definition of undue influence, but in Ettridge, the court described it as improper pressure. Okay, well, what do you mean by that? Good question. And remember, there are two types of undue influence. Actual undue influence, which is very difficult to prove, and we'll look at this in a moment, in that the weaker party has to prove that undue influence had actually been exerted on them by the stronger party. Okay, very difficult to prove in practice, but the much more important type of undue influence is called presumed undue influence. And if you are in a Class 2A relationship, the presumption arises, but it can be rebutted. If you're in a Class 2B relationship, the presumption will only arise if the weaker party can prove certain things, such that they have reposed trust and confidence in the other party and then entered into a contract which calls for an explanation. Okay, so let's elaborate on that a little bit more. Let's first of all have a look at actual undue influence. So actual undue influence, as I say, is the less important type of undue influence. It is covered in your notes on page 125 and the following. And the leading case here is the Avoidable case in dealing with actual undue influence. Okay, as I say, very difficult to prove actual undue influence. Okay, and you've got the facts there. Avoidable was a wife 20 years younger than her husband. So who's the stronger party here? All right, you would think the husband. And she had married him when she was only 17. Oh my goodness. For many years, she signed documents related to her husband's business, of which she was nominally a director, without reading them. Oh no, you should read it. What case do you think of when it comes to signing documents, everybody? You know, Lestrange and Grocott. Now remember Lestrange and Grocott, if you sign a contract, you are bound by all the terms, even though you haven't read it. Okay, anyway, she signed these documents without reading them or questioning her husband about them. I mean, because do you question your husband? She said, he'll probably say, "Here, dear, here's a document, sign it." She signed guarantees and charges relating to their matrimonial home in order to secure loans by the bank for her husband's business. She had not taken independent legal advice. Circle those three words, top of page 126, independent legal advice. Because one of the main ways of rebutting any claim for undue influence is to provide evidence that the weaker party has been given independent legal advice. And if there is independent legal advice, that rebuts any claim for undue influence. Okay? Initially, the wife actually did not succeed because the law at that time says that she has to enter into a transaction which was to her manifest disadvantage, which is a very vague word, okay, and not clear exactly what that means, but similar to, a transaction calling for an explanation. But the law has changed since Avoidable. Later cases such as CIB mortgages and PIT on page 126 saying that if you are alleging undue influence, you don't have to show actual undue influence, you don't have to show manifest disadvantage. Okay. But the important thing about Avoidable is that it's a case of actual undue influence. She was able to prove actual undue influence, but the law at that time says you have to also show that the contract you entered into was not to her manifest disadvantage, and found that the facts she was guaranteed loans had given the company a reasonably good chance of surviving, and that was actually of a benefit to her as the wife. Okay, so the point about Avoidable is that if that case was decided today, that the wife would succeed, okay? Because the law had changed with the Pitt case, in which the case that with regard to actual undue influence, the weaker party doesn't have to show manifest disadvantage. Okay, so that's actual undue influence. I think actual undue influence everybody probably should know, not really must know. You're not really going to get too much on that in an exam question. Well, you could mention it in an exam, depends on what the question is, but certainly you should in an exam question, which might come up in part A of the exam, explain what undue influence is and what effect it might have on a contract. Well, certainly you can mention that there are two different types, actual undue influence and presumed undue influence, but I'll very quickly point out that with actual undue influence, the burden of proof is on the weaker party, and it's very difficult to prove in practice, okay, that there was actually undue influence exerted on you by the stronger party. It's much easier and much more common to allege presumed undue influence. And with presumed undue influence, a presumption will arise. Now, it's important to emphasize the presumption only arises. It doesn't mean there is undue influence. It will arise in a Class 2A relationship automatically. It will arise in a Class 2B relationship provided the weaker party can prove those elements, namely they have reposed trust and confidence in the stronger party and then entered into a transaction that calls for an explanation. What do you mean by calls for an explanation? Well, later cases have said it's not explained by the ordinary motives of ordinary people. Actually, I've got that in the next PowerPoint coming up. Okay, so these classes, Class 2A and 2B, they were laid down in a case called O'Brien, a House of Lords case. Ettridge, which is the leading case, and we're getting onto that in a moment, wasn't all that keen on this Class 2A and 2B, but they said, well, it's sort of a fairly useful classification. I think it's good to have this, okay? So be careful, though, with regard to the presumed undue influence. It doesn't mean that you're presuming there is undue influence. It just raises the presumption of undue influence, but it is a rebuttable presumption. How can the stronger party rebut the presumption? Normally by proving that the weaker party has been given independent legal advice. Okay? Independent legal advice. So ILA is independent legal advice, and it's actually in your course manual, top of page 126. Okay? Independent legal advice. Okay, everybody, so we're about to have a look at the very important case of Ettridge, and Ettridge is an important one, and I think because we're going to spend a bit of time on that, probably a good time now to have our second short break. So I'll have a short break. After the break, we'll tackle the leading case on undue influence, which is the Ettridge case. Okay, everybody, welcome back. Sorry about my message in the chat box, a little bit messy. So it's into the final stretch tonight. Okay, so before the break, we're talking about, let's quickly go back to the beginning with undue influence. Remember, we've looked at duress. Duress is the common law doctrine. And of course, duress means, can be threat of physical violence. Obviously, that will render a contract voidable at the option of the innocent party, because remember, a contract has to be freely entered into, voluntary. Okay, and if somebody's threatening you with physical violence, you are not entering into the contract voluntarily. Okay, and so at common law, if you can prove duress, whether it be physical duress or indeed economic duress, the contract is rendered voidable at the option of the innocent party. Okay, so we know that. And also, we have now undue influence. Undue influence is the equitable counterpart of duress. And with regard to undue influence, it's a more subtle form of pressure exerted by the stronger party on a weaker party in a relationship, so that the stronger party exerts this improper pressure on the weaker party to enter into a contract with them. Now, obviously, this can also be a situation where the weaker party is not really acting voluntarily. And so inequity, and of course equity is a doctrine of fairness, that would not be fair, because then you could argue the weaker party is not entering into it voluntarily. They have been unduly influenced. Okay, and if undue influence is proven, it renders the contract voidable at the option of the innocent or weaker party. Okay, we'll get on to the third bullet point later. The third bullet point, where there is undue influence, or indeed can be other wrongdoing, such as duress or misrepresentation by a third party on a party to a contract, and the party to the contract is the weaker party who enters into a contract with a bank, for example, typically a bank. Then the weaker party may say that this wrongdoing has been exerted on me by the third party, the stronger party, and therefore if I entered into a contract with the bank, then the contract with the bank should be made voidable as well. And so that's the argument that the third bullet point is talking about. We'll get onto that a bit later, okay? So remember, with undue influence, there are two types: actual undue influence. The problem with actual undue influence is the burden of proof is on the weaker party, that there has actually been undue influence exerted on them by the stronger party. And that can be very, very difficult to prove. In the Avoidable case, the young wife was able to prove it, and indeed in the Pitt case as well, a wife again induced by her husband to remortgage their matrimonial home. The court found there was actual undue influence in those cases, and Pitt has changed the law, because Pitt said, well, whereas before the weaker party had to show that the transaction they entered into was to their manifest disadvantage, which is always a problematic phrase. Basically, it means, there is, it's to your detriment. Okay, but the court has clearly said, the House of Lords in Pitt said, that once actual undue influence has been proved, it is not now a requirement to show manifest disadvantage. So providing you simply show that undue influence was exerted on you by the stronger party, then the contract is automatically voidable, and it doesn't matter whether the transaction's to your benefit or detriment or whatever. Any transaction can be is rendered voidable at the option of the innocent party. So that's the result of the House of Lords case in Pitt. And you'll notice the years then, and Booty was a bit unlucky then, because the young wife, when she brought her claim, there was that requirement for this manifest disadvantage, but that's now gone. So if a Booty were to be decided today, they could rely on the Pitt case, and the young wife would probably would succeed. Okay, but actually, it's very difficult to prove. And so much more common type of undue influence that's pleaded is presumed undue influence. And you have to appreciate there are two types of presumed undue influence depending on the type of relationship. And if you're in a Class 2A relationship, which is on the screen, doctor-patient, solicitor-client, parent-child, then the presumption automatically arises. Does that mean there is undue influence? No, it just is presumed, but it's rebuttable presumption. And how do you rebut it? By proving that the weaker party has been given independent legal advice. Okay, and of course the other class is called Class 2B, and this is where the weaker party has reposed trust and confidence in the stronger party, and then entered into a contract or transaction that calls for an explanation. Calls for an explanation not explained by the ordinary motives of ordinary people. And that's what we're talking about before the break. And the leading case on undue influence generally is the Royal Bank of Scotland and Ettridge case, which is mentioned in your course manual on page 128. And Ettridge is a good case. I mean, if you want to know everything about undue influence, get hold of the judgment in the Ettridge case and read it. And I'd say, hang on, I haven't got time to do that. I've read it. I mean, it's not that long. And, you know, once you go, it does sort of go through all the history of undue influence. Okay, I mean, for example, giving gifts at Chinese New Year, could that be construed as undue influence? That type of thing. But Ettridge is a good case because it clarifies previous cases. The leading case before Ettridge was the case of O'Brien. And O'Brien actually gives us this Class 2A, 2B classification, which Ettridge wasn't all that clear on. But now Ettridge is the leading case, particularly on presumed undue influence, and particularly with regard to Class 2B. Okay, and it does mention what I've already mentioned. Class 2A, we've got the special relationship, but Class 2B is where one party places trust and confidence in the other party, coupled with a transaction that calls for an explanation. And later cases after Ettridge explain what this phrase calls for an explanation means, not explained by ordinary motives of ordinary people. It's sort of ask yourself, why did you enter into that contract when you know you've got everything to lose and nothing to gain? Why did you enter into it? That's the type of thing we're talking about. So if you do enter into a transaction that is not explained by the ordinary motives of ordinary people, then the presumption arises. And I emphasize again, arises. It doesn't mean there is undue influence, it just arises, but it can be rebutted. And the main way of rebutting it is by making sure the innocent party has been given independent legal advice. Okay, so far so good. And what about Ettridge? Is Ettridge followed in Hong Kong? The answer is yes, because the leading case on undue influence in Hong Kong is Li Xiaoying in the Bank of China, which is on page 132 of your course manual. And in Li Xiaoying, the leading judgment was given by Lord Scott, NPJ. What does NPJ mean? No pyjamas? No. I mean, it's getting hot. Do you sleep with pyjamas these days? Non-permanent judge. And Lord Scott was on the House of Lords, sat in the House of Lords when Ettridge was decided. Okay, the judgment in Ettridge was by Lord Nichols, but Lord Scott was also in the House of Lords in the Ettridge case, and so he was lending his expertise in this area in the Hong Kong case of Li Xiaoying and the Bank of China. And so the court pretty well applied Ettridge, okay, and in both, I think in Li Xiaoying, and also the other case, which is the Bank of China and Wong Kin Sing, which was a Court of Appeal decision involving the recently retired Chief Justice, Geoffrey Ma. Excuse me. In both those cases, the court found that there was no undue influence. And in both these cases, we're talking about a Class 2B situation. And in the Li Xiaoying case, the court found there was no undue influence. There was a relationship of trust and confidence, yes, but the weaker party did not enter into a transaction calling for an explanation because they were set to benefit from the transaction anyway. So the presumption didn't even arise in Li Xiaoying. It's a Class 2B relationship. The first element was established of a relationship of trust and confidence, but no transaction calling for an explanation. So the presumption did not even arise in Li Xiaoying. And in Bank of China, even more so, the court found there was no undue influence because it was involved two brothers. The weaker party was a Chinese university graduate, and the court found that he had not reposed trust and confidence in his brother. So in the Bank of China, Wong King Sing, again a Class 2B situation, but remember in the Class 2B situation, for the presumption to arise, you've got to prove you repose trust and confidence in the stronger party and enter into a contract that calls for an explanation. Well, in the Wong King Sing case, the claimant wasn't even able to establish a relationship of trust and confidence. So the claim for undue influence in Wong King Sing failed even more so than in Li Xiaoying. At least in Li Xiaoying, they were able to establish a relationship of trust and confidence, but not able to establish a transaction calling for an explanation. And even if the claimants had been able to establish both of those elements, doesn't mean there was actually undue influence exerted because the weaker party may have been given independent legal advice. Okay. But the important thing is that Ettrich does apply in Hong Kong. Li Xiaoying Court of Final Appeal from 2005 is the leading case. And so Ettrich applies not only in England, but it also applies in Hong Kong. So if you're doing any question on undue influence, try to work Ettrich into your answer. Okay, so remember, going back, that make sure you know what undue influence is. It's the doctrine in equity, the equitable counterpart of duress, arising out of the relationship between the two parties. And if you can prove undue influence, it renders the contract voidable at the option of the innocent, of the weaker party. Two types: actual undue influence, very difficult to prove, but if you can prove it, the contract is rendered voidable. In both Aboudi and Pitt, they were able to prove actual undue influence, but Aboudi in that case, the law unfortunately also had the requirement that the transaction had to be to that person's manifest disadvantage. Okay, but the more important type is presumed undue influence. Make sure you know the different classes. Class 2A, if you have a Class 2A relationship, presumption automatically arises. Class 2B, the presumption arises if the weaker party can establish those two elements, a relationship of trust and confidence, plus a transaction that calls for an explanation. But if that's the case, then the presumption arises, but it can be rebutted by the stronger party, proving usually that the weaker party has been given independent legal advice. So we're going to talk a bit more about what this independent legal advice is all about, but we're going to talk about it in a situation where we have, for example, a husband, or it sounds a bit sexist, but let's say the stronger party exerts undue influence on a weaker party, not to enter into a contract with the stronger party, but for the weaker party to enter into a contract with a third party, typically a bank. and typically where the weaker party is acting as a guarantor or give a guarantee of the stronger party's debts, okay? And remember, banks lend money, yep, but they won't lend money willy-nilly. They'll only lend it to you if you can provide an asset as security for the loan. And of course, land is a very important asset, and that's usually what's happened. Usually it's the matrimonial home. Okay, so this is the situation, and you have to look at this now from the viewpoint of the bank. Because usually what happens is that the weaker party who has entered into the contract with the bank will say, hang on, I have been unduly influenced by the stronger party, and this means that my contract with you, the bank, should be made voidable. So the question is, what's the situation of the bank? And the contract with the bank, is that voidable? Well, it will be voidable if the bank has notice. I emphasize the word notice, that's why it's in bold print, okay? And could you please explain what cause? Yeah, cause for an explanation, everybody, means you enter into a contract and you put up your property as security for a loan, for example, and you get no benefit out of it at all, but you could lose your whole home. So you ask, why did you enter into that contract? What's in it for you? There's no benefit for you, but there's all detriment. You could lose your whole property. Why did you enter into it? And the other cases say, well, cause for an explanation means not explained by the ordinary motives of ordinary people. Why? What's the reason for entering into this contract? There's nothing in it for you. So that's what we mean by cause for an explanation. Okay? So I trust that. So it is a pretty vague sort of one, but that's later cases have said that. All right? So if you're a wife, you put up security, your home is a security for loan. There's nothing in this for you. So why are you doing it? Okay? No, it's got nothing to do with consideration. It's just to, I know what you're getting at, but it's the consideration's not relevant here. Okay, it's just the court looks at why have you entered into a contract. Okay, so because you won't normally enter into a contract because you want to get something out of it, right? You get some benefits one way or another, all right? But why would you enter into a contract where you've got everything to lose and nothing to gain, okay? So that's what we're talking about here. So with regard to undue influence and third parties, the bank wants to know, will they be liable? Okay, will the contract with the weaker party be voidable? Well, it will be if the bank has notice of any undue influence on the weaker party by the stronger party. I've got H, but that's husband. And this notice can be of three types. Can be actual notice, means you know about it, you know. Or it could be imputed notice through an agent, okay? Or, and this is what Ettridge is all about basically, there's also another type of notice, and this is because we're in equity. It's a doctrine in equity, undue influence. And constructive notice means you don't know, but you were put on inquiry and you didn't take reasonable follow-up steps, okay? And what is reasonable follow-up steps is a good question. We'll look at that in a moment, okay? So let's have a look at constructive notice. What do you mean by where the bank is put on inquiry? Well, in Ettridge, the court said that the bank will be put on inquiry whenever the transaction is non-commercial, which means domestic. Why is this? Because if you're the bank and you want to know whether there's any undue influence exerted on the weaker party, let's say the weaker party's the wife, or no, that sounds sexist. So how do you know? Well, you could ask the wife. They'd say, hello, you're married? Yes. You live with your husband? Mm. Do you sleep together? You say, oh, go away. You're asking very personal questions. So how does the bank know in a domestic situation whether there is any undue influence exerted on the weaker party? Well, instead of being asking these very personal questions, then Ettridge, Lord Nichols saying, well, if that's the case, the bank will be put on inquiry whenever the transaction is a domestic or non-commercial transaction. And if you are put on inquiry, you better take reasonable steps to follow up. Otherwise, you will be fixed with constructive notice of any such wrongdoing, and that will affect your contract with the weaker party. Okay? Now, what these steps will be, basically, everybody, is make sure that the weaker party is given independent legal advice. That's what you do. So instead of asking very personal questions dealing with the relationship between the weaker party and the stronger third party, then you simply make sure that the weaker party has been given independent legal advice. Okay? And so what are these steps that the bank should take in order to avoid being fixed with constructive notice of any wrongdoing? But when I say any wrongdoing, it could be undue influence, it could also be duress or misrepresentation. Okay? So what are the steps? Well, what we should do as a bank is that you should advise the weaker party, the innocent party, IP, face-to-face to take independent legal advice. You should also, as the bank, provide the necessary financial information to the weaker party's solicitor. Inform them if there are any suspicions or fears about the transaction they're entering into. And also the solicitor should give written advice that the weaker party has had the contract explained to them. So the solicitor should sit down with the weaker party and go through that contract clause by clause and make sure that the weaker party understands this. Okay? And of course, if the weaker party said, oh yes, okay, I'm entering into a contract, I know I could lose everything, I could lose my house, but I'm prepared to do it, well, fine, then so be it. There's no undue influence there. And these guidelines, which are on the screen, have been followed by the Hong Kong Law Society. So if you're a solicitor in Hong Kong and your client is a bank, then you would make sure that the bank takes all of these steps so that they would not be fixed with constructive notice of any wrongdoing that might be exerted on the weaker party. Okay. Now, interesting, isn't it? These steps are a bit like an umbrella for the bank. I mean, I'm not sure about, I mean, you're all at home at the moment, except me, but what happens if you're not sure whether it's going to rain or not? Well, if you think it's going to rain, you better bring your umbrella. Okay? If you're not sure, well, perhaps you should bring your umbrella anyway. If it rains, you're protected. If it doesn't rain, no problem. So in a way, these steps on the screen are a bit like an umbrella for the bank. If there is no undue influence exerted on the innocent party, well, fine, no problem. But if there is, you've got your umbrella, that will protect you. Okay, so that's one way of putting into context, if you like, the steps that a bank has to take in order not to be fixed with constructive notice of any wrongdoing exerted by a stronger third party on a weaker party to the contract with the bank. Okay, so that's Ettridge. Now that pretty well finishes undue influence, okay, and we'll follow up a little bit more next time. Let's go through very quickly this one, illegality. Now let's go sort of right back to the start. Oh, it's very slow. How come you're very slow? But remember well, we may not go through illegality tonight because this is going so slowly. I don't know how I can speed it up. Anyway, so we're looking here, everybody, at the vitiating elements, the elements which can affect the contract, either make it void or voidable. But there are also other possible consequences, depending on what the particular element is. Okay, so let's quickly go through what we've covered tonight. Tonight we've covered misrepresentation. Must know, probably misrepresentation is the most important vitiating element from your point of view. Make sure you know everything about misrepresentation, including the definition and including the different types of misrep. What type of misrep would you advise your client to claim? You know, negligent misrep. Why? You know, mainly because of the legislation, Section 3.1 Misrep Ordinance, okay? And remember, misrepresentation renders a contract voidable at the option of the innocent party. So does duress, so does undue influence, okay? Duress, particularly economic duress, is must know, economic duress. Undue influence must know as well, and undue influence renders a contract voidable at the option of the innocent party. Remember, undue influence is a doctrine in equity, and it deals with more subtle forms of pressure. And remember, two types of undue influence: actual undue influence and presumed undue influence, which is what we just covered. Okay, next time we meet, which is Tuesday next week, we'll deal with unconscionability. And I've got in brackets illegality. Now, illegality is really might like to know. I'm going to cover illegality in just one PowerPoint. We won't do it tonight because we're just about out of time. The odd thing is that your course manual deals with illegality in quite a lot of detail. In fact, I'm just flicking through. It starts on page 134 and goes all the way through for about 20 pages. I mean, incredible. I didn't write the course now. I don't know why it's got so much on illegality. But everything from page 134 through to page 155, forget about. Okay? Illegality does have an effect on a contract, but for our purposes, it's might like to know. And the effect varies depending on the facts of each case. But I will touch on illegality very, very briefly next time, but everybody, it's might like to know. What is must know will be unconscionability, and we'll deal with unconscionability next time we meet. Okay, so very quickly, misrepresentation, must know, probably the most important must know. Mistake, should know. Duress, undue influence, must know. Unconscionability, must know. Illegality, forget, might like to know. Okay, so that's it for tonight. Sorry about our little technical problems tonight, but I think we sort of got there in the end. All's well, that ends well. Okay, and thank you for your questions. Thank you for your attention, and we shall meet again. I think it's Tuesday. Is it Tuesday next week? And we'll finish off vitiating elements, and then we get on to the termination of a contract. So you might want to read ahead so that you're sort of up to date. And we'll finish off vitiating elements on Tuesday, then get on to how you actually terminate a contract. Okay, so thank you very much. Go and have a nice hot chocolate or whatever. You might even have a shower tonight because it's a bit sweaty, even though it's not that cold anymore. Okay, so thank you very much. So that's it for tonight, and I'll see you all next Tuesday. Have a good weekend, yes, and do some reading up so you're ready for our next session. Okay, thanks very much, and good